What's up, everyone? It's Peter Trey Goes the Lawyer You Know, and today we're going to talk about whether or not Jussie Smollett was subject to double jeopardy and whether or not he has a chance to win on appeal for that issue and get this conviction thrown out because he was already put in jeopardy and punished for this crime once before when the charges were dismissed by the previous state attorney. So we're going to dig into that a little bit today. We're going to talk about double jeopardy, and in the comments, as always, I want you to let me know what you think, if you think this was double jeopardy or not. But if you haven't subscribed to our channel, take a second, go to the page, subscribe to our page so you can get all the videos and content that we put out, and you can be part of the community and the discussion about what content we bring you in these videos, because this is a video specifically requested from a couple of our other Jussie Smollett videos that you wanted me to break down whether or not I thought this was double jeopardy, if he's got a chance to win based off of this, and we're going to discuss that today. So if you're interested in this content and you asked for this video, hit the like button. If you're interested in Jussie Smollett content, hit the like button. If you just like our page, hit the like button. So let's jump into it, okay? And before we get to specifically Jussie Smollett's case, let's talk about what double jeopardy is and what it isn't. Double jeopardy is not an outright protection that once you get charged with a crime, if the state attorney dismisses the case, you can never be charged with that crime again, because that is in fact not the case. There are statute of limitations that bar certain charges from coming later on once the statute passes, but just because the state attorney's office files a charge and then dismisses it or removes it or goes away, they can still come back on those charges. What double jeopardy protects is that you really are not in jeopardy of being punished twice for the same crime. And there are some things to unpack there. So first, what does it mean to be in jeopardy? Obviously, if you're charged with a crime, you're in jeopardy, but that is not when double jeopardy attaches. It usually attaches when a jury is impaneled and sworn in and the trial begins, because now you're sitting there, your life and liberty is in the balance as a criminal defendant, and you're in jeopardy, and jeopardy has attached. So if you go and win and you get acquitted and it's not guilty, you cannot be tried again for that same case. That would be double jeopardy, would attach. If you go and lose and are convicted and found guilty and punished and sent to prison, you cannot be tried again for that same case, because that would be double jeopardy. You'd be put in jeopardy of being punished twice for the same case, okay? But there's also a third way. If you plead and take a plea bargain and you plead guilty or no contest, then you get your punishment, whether it's probation, a fine, whatever it may be, and you cannot be charged and tried for that again. That would be double jeopardy. So basically, you go to trial and win, you go to trial and lose, or you take a plea deal, you cannot be tried again for that same case. There are some issues we won't go into with trial. If there's a mistrial, there are certain ways where double jeopardy does attach, certain ways that it does not, dealing with prosecutorial misconduct. If they wanted a mistrial on purpose, we won't get into all that for Jussie Smollett's case because that didn't happen here, but we are going to focus on the plea deals, because that's kind of what I think they're going to argue, is that he had a plea deal with the first state attorney that gave him the deal and dismissed the charges. And we're also going to focus on whether or not it is the same case, because Jussie Smollett was charged with one disorderly conduct the first time. They slapped on 16 additional charges. Then there was an investigation once the state attorney dismissed the case and a new special prosecutor brought the charges. They brought different or new charges. But in reality, was this all the same case? And I would argue, yes, it is the same case, because in order to be the same case, it has to come out of the same facts. There has to be the same evidence that would be likely to be produced at trial in the two cases, and it has to be part of the same transaction. So as an example, if I go to a drug deal, buy some drugs, and then murder the drug dealer, and I get charged with murder, and it's not guilty, and I win, well, they can still later come and charge me for possession of drugs or purchasing illegal drugs. Because even though that's the same transaction, it's not necessarily the same evidence if they didn't put that evidence in and add those charges on, which they probably would have. But if they kept them separate, it could potentially be two cases. But what they couldn't do is, if I went to trial and was not guilty for murder of the drug dealer, they couldn't then charge me with aggravated assault. They couldn't then charge me with endangering the people around him from shooting the gun, because they already prosecuted me for shooting the gun for those actions. The same crime would be in place, the same evidence would be in place, it's the same transaction. Okay? So even though the drug deal turned into murder was all one transaction, you can see how that's kind of separate. And that's just kind of a juvenile. There are a ton of it depends and things we could go into as far as nuance with those things, but I think you understand. Separate evidence, separate crimes, you can separate them. The same crime, the same evidence, you cannot separate them. You cannot be charged twice. It cannot be double jeopardy. For Jussie Smollett's situation, it was all built around the fake hate crime with the noose and the MAGA and the jumping and the beating and the telling police about it and lying to police. Okay, the disorderly conduct, the false police reports, it's all the same transaction. It's all the same evidence, whether it would have been tried on the first set of charges, the second set of charges. In my opinion, it's all the same case. So he checks that box as far as you cannot be tried twice or put in jeopardy twice for the same case. Let me know whether or not you think it's the same case or not, or if you think they could have separated it somehow in the comments by putting same case or not the same case in the comments. So that's box number one we want to talk about with Jussie Smollett. Now, let's get to box number two to see if he was actually put in jeopardy twice. So we know he was not tried twice for the same crime, so we can just push those away, that he was not either convicted twice or not guilty and then they charged him again and tried him again and was convicted. That is not the case here. So we have to look to a plea bargain or a deal made prior to being tried the second time, which would have been the double portion of putting him in jeopardy. So when we talk about the deal Jussie Smollett made with the prosecutor initially, that deal was the charges got dismissed and he forfeited his $10,000 bond. Now, is that punishment? Was he put in jeopardy? I think there was some community service hours as well. There are many cases where a fine and community service is the punishment and penalty you get for that case. There are many plea deals where you plead guilty or no contest for a fine or community service. And in Florida, there's pretrial intervention, and other states have diversion programs as well, where you go, you do these hours, you take these classes, and at the end, all the charges are dropped and the cases are dismissed. They're not on your record. However, in just about every one of those circumstances, you have to admit wrongdoing. To plead guilty or to plead no contest, you are admitting wrongdoing to a certain factual basis. And that factual basis is read in that plea hearing. The judge will say, what's the factual basis for the case? And the prosecutor will say, Mr. Tragos drove up to the drug deal and pulled out his gun and shot the drug dealer in the chest. He's pleading no contest to this. That would be the factual basis to the murder in the drug deal, okay? So then I would say, Judge, I plead no contest or I plead guilty. That would be on the record. I would get punished, and that would be it. I would attach for double jeopardy even without having a trial because I'd have punishment laid on me from the court, and I would admit wrongdoing. And there was a transaction, a bargain for exchange there. In a pretrial intervention where the charges are all dropped, you still have to sign a document, at least in Florida, I'm sure states handle it different ways, where you admit that you did whatever it is that they are charging you with. Pretrial intervention is usually for lesser crimes. Let's say petty theft. I stole a pack of underwear from Walmart, got charged. I go to through the program. I take, shoplifting school, whatever it is, shoplifters awareness. I do some community service. I pay a fine and I sign that, yes, I admit that I stole this stuff, and the state drops the charges and my record is clean. I have no convictions, but there's documentation. There's reasons why everything happened, and we can see that. There was a punishment as far as the diversion program goes, and the court would recognize that as jeopardy attaching. But what do we have here? We have Jussie Smollett accepting no wrongdoing, admitting no wrongdoing, pleading nothing, not no contest or guilty. We have no punishment specifically levied or recognized by the court. We have him voluntarily forfeiting his $10,000 bond. There's no written agreement as to why he forfeited the bond or what that was in exchange for. There was no written agreement that the dismissal of the charges was contingent on him forfeiting the bond. That bond was not a fine specifically allocated to the police investigation or victims or anything like that, which usually you'd have in a case like this. and there was some prosecutorial misconduct, even though it didn't lead to criminal behavior that happened, that she may have overstepped her bounds, or there was outside pressure, political pressure to make her dismiss these charges when she shouldn't have. And they did this whole huge investigation that said, no, there needs to be criminal charges against Jussie Smollett. So it's the forfeiture of that $10,000 that really makes this a gray area. Because if she would have just dropped the charges, given him his money back, it would not be double jeopardy. There'd be no punishment. There'd be no jeopardy. They would have just dismissed the charges and then they could refile them later within the statute of limitations. That can happen. So that's really what makes this a gray area. And a lot of people want to compare it to Cosby, and I can understand that comparison because Bill Cosby was charged. Those charges went away. Then he was charged later and convicted, and it turns out some deal he made with the prosecutor got him off after he was convicted and served some jail time. However, there was a major difference here because in Cosby's case, the dropping of his criminal charges was contingent on giving him immunity, forcing him to waive his Fifth Amendment right and testify in the civil cases. And that testimony, which was subject to the immunity agreement, was then used later to convict him on criminal charges. Now, whether or not we agree with what that state attorney did, whether or not we believe he has authority to do it, whatever, the point was, the court found in overturning Cosby's convictions that he believed he had to waive his Fifth Amendment right, protecting him from criminal prosecution because of that immunity deal with the state attorney. That's what made him testify in those cases, those civil cases, and then that testimony was used against him in the criminal case. That's exactly what we want to prevent. That seems like prosecutorial misconduct in getting around the Fifth Amendment. We don't have any of that here. We don't have any immunity agreement for Jussie Smollett. We don't have any civil cases that I'm aware of. We don't have any testimony that was used against him in prior civil cases that was subject to that immunity agreement. We don't have anybody forcing him to waive his Fifth Amendment right by giving him immunity. We don't have any of that in this case. All we have is a potential plea deal and punishment to Jussie Smollett that would not allow him to be punished again for the same or similar acts. So while I think we have same acts, I don't think we have double punishment or putting Jussie Smollett in jeopardy of that punishment twice. Because I don't think there's a factual basis. I don't think there's a plea deal. I don't think there's any admission of guilt. I don't think there's anything Jussie Smollett did in that first set of circumstances where he was charged and then the case was dismissed and he forfeited his bond. I don't think anything there constitutes jeopardy as it is written and protected in the Constitution and as it's been applied by the states. Now, my opinion is not the end-all be-all. I'd like to hear from you in the comments. Put DJ if you think it was double jeopardy, and put no DJ if you don't think it was double jeopardy, if he was not in jeopardy that first set of circumstances. It is very interesting, and I'm interested to hear kind of how it's broken down in the legal arguments and what the court says in their order, because I do think it's a very interesting set of circumstances. And I think it's something in the future that maybe defendants could use as a loophole, or maybe prosecutors can make sure something like this doesn't happen. It seems like this was a very strange case, and there was a lot of outside influences that were influencing the decision makers of a lot of the important people in this case. Nevertheless, he did lose $10,000, and most of us, I think, would consider that a punishment. So while I don't think legally speaking he was put in jeopardy twice, I can understand why you or Jussie Smollett may disagree. And that's what I want to hear from in the comments. Now, as usual, I like to talk about some procedural history and how I think that'll affect the case. This is not a new argument. A year or two ago, Jussie Smollett's lawyers already made this argument that it was double jeopardy. And not surprising if you watched the sentencing breakdown, Judge Lynn did not disagree. And here's a quote from Judge Lynn. There was no trial in this case. This is prior to the initial criminal trial when they were arguing even being charged twice was double jeopardy. There was no trial in this case. There was no jury impaneled, no witnesses sworn, no evidence was heard, no guilty pleas were ever entered. Nothing like that happened in this case, and he was not punished by the court. There was no adjudication of this case, meaning it did not even come to a completion the first time in order to be single jeopardy, let alone get to double jeopardy. That's what Judge Lynn found, and I think that's a correct ruling, and that's what I think will stand. But the appellate court may not feel the same, which is why they're letting Jussie Smollett out. They at least think maybe there's some merit to this appeal. So we'll see if Judge Lynn's comments and his feeling on what the state of the law is in line or in contradiction with what the appellate court thinks, because this is going to be their main argument. This is the major argument of the defense. I will tell you, in appeals, everything gets harder once you're convicted. Everything gets harder once judges, who are people, they're human, and they think you took the stand and lied and committed perjury. It's harder for all of this to get overturned. However, this is not as bad as the Bill Cosby situation, the Bill Cosby facts and his conviction and his crimes, which is why he was not out pending his appeal. He was sitting in prison waiting for his appeal to be heard. We talked about the different circumstances in this case and why it might be okay that Jussie Smollett's out pending appeal. You can go check that video out if you haven't heard it already. But there's major differences there in how those factors are looked at between Cosby and Jussie Smollett. But this is a very interesting legal argument. We'll see. I don't think it's double jeopardy. I can't wait to hear what you guys think. But let me know if you have any questions or if you want to hear more about this specific content or anything else with Jussie Smollett's appeal. Put it in the comments and we'll keep bringing you the content you're interested in. But for now, that's all we've got. Thanks for watching this episode of The Lawyer You Know. If you like this content, please share it with your friends. Make sure you subscribe to our page and like our videos. If you want some interaction, get in the comments and we'll be sure to get back to you. If you want to know any more information about our firm or this page, you can find out in the description or visit tragoslaw.com. We post multiple times throughout the week, so make sure you hit that bell so you can get the notification and not miss out on the next episode.